Washington Confidential, the Karen Reed murder trial, starts right now.
After 9 weeks of testimony and nearly 70 witnesses, the prosecution rested its case in the Karen Reed murder trial. Thank you for joining us. For Canton Confidential this Friday, I'm JC Monahan.
And I'm Glenn Jones. The defense calling its first witnesses and at one point even moving to have the case dismissed.
And we will get to all of that. But first, let's take a look at how the Commonwealth wrapped up its case.
Now, doctor, from the internal and external examination that you conducted in regard to Mr. O'Keefe, as well as the other materials that you reviewed, were you able to come to an opinion to a reasonable degree of medical certainty as to the cause of death of John O'Keefe?
Yes, the cause of death was due to blunt impact injuries of the head and hypothermia. I was not provided with enough information for me to be able to determine the manner.
What, if anything, can you say about what that blunt object could be?
It could be any blunt object.
Whether you agree that John O'Keefe's injuries, or lack thereof, are inconsistent with having been struck by a vehicle at 24 miles per hour.
Likely and unlikely at the same time, depending on the position of the body and the vehicle in question. They're not the classic pedestrian injuries that we observe, no.
All right, Mr. Lally.
Thank you, Your Honor. Commonwealth arrest.
We want to begin tonight with a conversation about what the prosecution presented to the jury over the past 2 months. Joining us in the studio tonight is local attorney Margietta Derissiere and our courtroom insider and commentator Sue O'Connell. So let's begin where we were just listening to that final witness for the prosecution, the medical examiner, who was unable to come up with a manner of death on the injuries to John O'Keefe's arm. She could not say whether or not they were caused by a car collision. And she also conceded that the injuries to his face could have come from punches. So in the end, was she an effective closing witness for the Commonwealth?
To be honest, I don't think so. And I think that because there have been so many witnesses, we were waiting for this aha moment to come from this medical examiner. And to be honest, I don't think that the jury got that. I don't think we got that. And it's really unfortunate because the Commonwealth's cases rest, right? And they can't put any other witnesses on except for going through the defense's witness and questioning them. So I don't think that point was made, and I think it's kind of unfortunate.
Sue, did you get that feeling from the jury of how they reacted to a very mild prosecution rest? You know, again, waiting for that, like, where's the bang? Where's the firework?
We were unclear that he rested. That's sort of how the energy level was when he ended, that it was just prosecution rest, you know, or the Commonwealth rest. And we were just, did he say the Commonwealth rest? You know, we're in the courtroom. We don't hear the feed like you guys hear the feed. So that's what the jurors heard too. We don't have, so it was just kind of a letdown. And I have to say, during the doctor's testimony, and I would say, listen, she wasn't a letdown. She just was unable to meet the charges that have been brought against Karen Reed. That's what the letdown is.
That's an important distinction.
She testified with what she had. She testified with what the reports that were given to her were. And there was she seemed different today. The doctor did as well. Just like, I'm just going to go through this and tell you what I know. And good luck to all of you. I'm doing the best I can here with what I had to work with. But I could just see some jurors just looking at her like, in my opinion, waiting to hear something. And then when the defense got up for their cross and it was like, could it have been a bat? Sure, it could have been a bat. Could he have just fallen down and hit his head? Sure, he could have fallen down and hit his head. Of course, all those things are true because they don't have they don't have a witness. They don't know what happens. And when she was talking about how these injuries were not necessarily typical of a pedestrian hit, when she said that, the words that she used to say that, you could see, I saw one juror just go.
Well, she dismissed all the marks that everybody's been talking about on the arm. We'll talk more about that a little later. But the scratches were superficial. They're not the cause of death. And she's a medical examiner. She's not there to determine what caused the scratches. She just basically said it didn't contribute to his death. So therefore, I have nothing more to say on that. Am I right?
Right. And so going back to that point, it's the prosecution's burden to prove this case, right? So we don't even really have to address whether it's dog bites or not. We have to address whether or not Karen Reed is guilty of using a vehicle to, kill John O'Keefe. And that point wasn't made. And I think that needs to be the focal point. And, when I was saying that's pretty much underwhelming, it's because we waited so long for answers, and we have not gotten answers yet.
Speaking of the Commonwealth meeting its burden, right after the prosecution wrapped up its case, the defense attorney, Alan Jackson, moved for a directed verdict from the judge. Let's listen to that part of his argument.
The court must consider, after viewing the evidence in light most favorable to the Commonwealth, whether a rational jury can find the elements of the charges beyond a reasonable doubt. And here, the case that the Commonwealth has submitted to the jury after resting is insufficient to meet such a finding. There must be evidence that the vehicle killed John O'Keefe. There has been no competent evidence presented in the Commonwealth's case that Karen Reed's vehicle actually struck John O'Keefe. There's been conjecture, there's been speculation, but no actual competent evidence. In our view, the court is required to find Ms. Reed not guilty of counts 1, 2, and 3.
Ultimately, the judge denied Jackson's motion, but you were not surprised to see that motion.
I was not surprised to see that motion. I was also not surprised to see that it was denied, right? So what the required finding of not guilty, as in Massachusetts we call it a directed verdict motion, is always presented 9 times out of 10. Defense attorneys will present it because they have to, right? And in the beginning, when I talked about appealable issues, if that issue particularly isn't raised, it could be something that, could come back to the defense attorneys later on. So they are required to do it. It's pretty standard in every case. I'm not surprised that it was denied.
Okay.
Well, listen, now that the prosecution is done, it is time for the defense to begin calling witnesses. And today we heard from 3.
That included a snowplow driver who was on the road in the early morning hours of January 29th, as well as the dog bite expert we heard from earlier this week. Then the day finished with a digital forensics expert on the stand. Our Kirsten Glavin gives us a recap.
Well, Karen Reed's defense team tells me they only have 3 witnesses left to call. They expect to wrap that up on Monday, with closing arguments likely on Tuesday. After that, it will go to the jury. After 28 days of testimony, prosecutors for the state resting their case in the Karen Reed murder trial after finishing with their last witness, the medical examiner.
Thank you, Your Honor. Call off the rest.
A Canton DPW plow driver then sworn in as a first witness for Reed's defense. The driver testifying that he made multiple passes by the home on Fairview Road throughout those early morning hours and did not see O'Keefe's body.
When you made that first pass by that residence at 2:45 in the morning, sir, with your headlights on, what, if anything, did you see on the front lawn in the area of the flagpole?
I saw nothing.
The prosecution questioning his eyesight after he admitted to hitting a basketball hoop.
So you hit it because you didn't see it, correct?
No, I was attempting to avoid the net by going around it.
Next up, a retired emergency room forensic pathologist testifying that O'Keefe's arm wounds were caused by an animal attack, likely a large dog.
There's also little punctate, incomplete puncture marks here, little round marks right there that were inflicted by the actual point of the tooth.
The defense has pointed to the Alberts, who owned the home on Fairview, having a German Shepherd that was later rehomed.
Based on everything that we've discussed today, Doctor, is it your opinion, based on a reasonable degree of medical certainty, that these injuries were from an animal attack, possibly a large dog?
Yes.
In her cross, the doctor pressed on how well she knew the case.
Were you being asked as an ER doctor to come to a quick conclusion in this case?
No.
But you did anyway.
It's how I'm trained.
The president of United States Forensics, a digital investigation firm, testifying next about O'Keefe's cell phone and health data, showing him taking steps in ascending 3 flights of stairs. Later, he testified Jennifer McCabe's Google search, "Haas Lawn to Die in the Cold," was first made at 2:27 a.m. The prosecution has said it was made after 6 a.m. later that morning.
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
He was also asked about McCabe's deleted calls.
What percentage of calls were deleted on Jen McCabe's phone within that time period?
Yeah, so we found no live data, so 100% of them would have been deleted.
How are you feeling right now leaving court? Strong. Outside of court, Reed's defense saying that testimony was more powerful than what the Commonwealth presented.
They can call 3 witnesses. They can call 30 witnesses. They're not going to measure up against Rick Green.
Again, we could see closing arguments happen on Tuesday. After that, the jury will have to answer the question, did the Commonwealth prove second-degree murder? Back to you.
Okay, Kirsten, thank you. A lot of interesting testimony there. Still ahead on Canton Confidential, what we can expect as the defense continues to call its witnesses.
Morgietta will join us back at the table. And don't forget to send us any questions you may have for one of our experts. Send us an email at canton.confidential@nbcuni.com. We'll be right back. Welcome back. We're joined again by local attorney Morgietta Dorissier, and I want to talk about the first couple of witnesses that the defense has now called. There were 3. The plow driver, did you see anything? The dog bite expert, are these dog marks? And then the forensic scientist on the cell phone of how's to die, long to die in the cold. They're very pointed. Those were 3 very specific witnesses for 3 very specific topics, something we haven't had up to this point. Is that because it's the defense and the prosecution has already put 67 or 8 witnesses on there?
And I think the defense is trying to, hit their points home. They've made a lot of points throughout this trial, and they don't want to belabor the jury, right? The jury has heard enough information that I think they're ready to make a deliberation. So the defense doesn't have to put on any case at all. Let's, remember and keep that in mind. But they just want to hit those specific points home, and I think that's what they're getting at with these witnesses, and I think 1 or 2 that are coming next week. Yeah.
So to JC's point about ADA Lally, it seems as if the strategy was to keep some of the physical and forensic evidence witnesses at the end of his case as opposed to the beginning. I guess you could do it either way. But now I'm starting to wonder, did he just not have the findings from any witnesses where it almost didn't matter what strategy he chose to use? There was just a lack of definitive, hard evidence that pointed to convicting Karen Reed on these charges.
So I think I said this, again from the beginning, strategy has to be really important. I know that the first many witnesses, they were focusing on the scene, right?
Yep.
And perhaps that had needed to be important, but I think the fact that they didn't put some of those forensic persons in the beginning really confused the jury. And now you're 7-8 weeks in and they're tired and they're confused. And even if they had strong points, it's probably not hitting them as closely as it could have because they're almost over it at this point, right? So I personally think that the strategy wasn't as clear. They should have put some of that stuff on in the beginning.
Who would you have ended with off the top of your head? I know I'm not giving you any time to think.
I've never been a prosecutor. But if I would have ended, I think the medical examiner in the beginning, but maybe some more of those character witnesses closer towards the end. I think that would
appeal to emotion.
Appeal to the emotion towards the end, but definitely not in the beginning.
Well, the medical examiner, as you said, you expected it to be some sort of bomb at the end because we've talked this whole time, the last 2 months, that I found it hard, if I were a juror, to decide who killed him when I don't know what killed him.
Right.
And we did, and even today we're still going, we don't know the manner of death.
Well, let's get to a viewer question really quickly, because this is interesting. The viewer is asking, there are a lot of objections to the format of questions where the judge tells the attorney to rephrase. What is incorrect in most of these objections about the format at which these questions are being asked?
And so, there's 2 particular types of questions, right? So there are questions that you ask on direct examination, which are open-ended questions: who, what, where, why. You want the witness to tell a story and what is it that they want to convey to the jury. And then there are another set of questions which are called leading questions, where you're controlling that person because you're supposed to know what the answer is. You want it to be yes or no or a specific question. Now, if the person is on direct examination, you don't want it to be yes or no. You want it to be open-ended, or vice versa. And I think that for clarity for the jury, the judge is saying, hey, they don't understand the question, or the question is confusing, or a compound question, as they call it. And so the judge just wants the facts to get out more clear to the jury, and so that's where some of these objections are coming from.
That's really helpful. Yeah.
Morgietta, thank you.
Thank you.
Well, there were quite a few sidebars in court today, which slows things down, but overall, the pace has picked up.
After the break, we ask our experts about ADA Lally's cross-examination strategy. That's next.
around 12:45 in the morning, when the vehicle was in front of the residence on Fairview, that for some perceptible period of time, that vehicle travels over 60 feet in reverse at over approximately 24.2 miles per hour. Page 10 on the text messages. With respect.
Okay, so Mr. Lally, when you put your head down and when you walk away, we can't hear you, and so there won't be a record of this. So you have to keep your voice up.
I will do, Your Honor.
Well, you just said you just put your head down and your voice went down. So keep your voice up. It's really important you do so.
So do you know that there is actually no street lighting whatsoever in the area of the fire hydrant, the flagpole, or anywhere there for several hundred feet?
Correct.
So you do know. And you're not, nor were you ever certified in forensic medicine, is that correct?
That is correct.
Pathology. And have you had a chance to review those materials as well?
Yes, sir.
You understand that they both disagree with what your opinion is in relation to those circumstances?
I absolutely understand that, sir.
So that was a before and after situation. ADA Lally was asked repeatedly to speak up by the judge during this trial, but of late it seems not to be a problem. I didn't really even recognize it was the same lawyer speaking. That's how different they were.
I assume you both noticed.
Yeah, in the courtroom, it is a stark difference. He is both very loud, which he has not been. Not once today was he told to speak up. He is also very aggressive. Now, he is, of course, questioning the defense witnesses, so that makes sense. But he's also talking over them, and he has been admonished at least 4 times today by the judge for not talking over the witness. And some of the jurors, the witness will be asking. We had a couple of witnesses today who had a lot to say, talked very conversationally and talked a lot. And when ADA Lally went to ask them a question, he spoke so loudly, one of them went like this, like, it was so loud it shocked her. So, I want to be careful because he's doing a lot of work. He's the only one out there, and it's been many, many days. But I'm wondering if it might have been helpful to introduce this guy a little bit earlier.
Well, that was my question for you, Morgietta, is that I just assumed while I'm watching, right? Well, that's Alan Jackson's personality. That is the prosecutor's personality. But if he's able to pivot like this, does that mean it was strategy?
You know, when you're admonished by a judge, you will be surprised at how many magical things will happen. And so you have to take those remarks from the bench, essentially, because not only do you want the record to be clear, but you want the jury to appeal to you. Believe it or not, a lot of times case rests on the presentation of that particular attorney. Shouldn't be that way, but I've heard that in the rumor mill. And so maybe he's making a final attempt to kind of bolster some, credibility with the jury.
Shouldn't he have done it? If that's the case,
right,
and you're being admonished, which Judge Cannoni has said to him multiple times almost every day of this trial, to please keep your voice up, again, I would have expected, if he was taking that feedback, to maybe have pivoted or shifted a while back.
And like Sue said, he's the only one doing it, right?
Yeah.
So he's leading at all of these witnesses. The defense has teams and people who are strategizing and talking at different points in time. And it could just be his own personality. Maybe he's trying to switch things up. But the reality is that you have to have a clear record. You have to be relatable to the jury. You have to make sure that your information is coming out clear and concise. And maybe he's just trying to do that towards the end.
Okay.
All right, Sue. So I think your reporting is that by the end of the day on Monday, the defense may be done putting its witnesses on the stand. And it sets up a scenario where the Commonwealth's case took 9 weeks and the defense case took 2 days.
Yep.
What does that tell you?
Well, to your point, the defense doesn't have to do anything, right? It's the Commonwealth, it's the prosecution's job to prove their case. And I think that with all of these witnesses that we've had for the prosecution, the defense spent a lot of time on them as well. It didn't seem as long because of the pacing and the different people, but they were able to get their story out without calling any witnesses. Like, for example, the idea that Jen McCabe was somehow involved in all this has never been presented directly to the jury. It was not in opening statements, and it's just kind of hung out there. The idea that the dog bites really didn't come into focus until just now, but it's been mentioned. So the defense has been able to float out a number of theories without having to say it directly, so they don't need to do that now because they've done that.
Wow.
Yeah, they think they've already established reasonable doubt. That's what it seems like.
Stay with us. Canton Confidential, the Karen Reed murder trial is back in just a moment. Our viewer, Kathy L., is asking, could you tell me who is sitting to the left of Attorney Yannetti, and why do the cameras keep zooming in on individual people in that area?
Yes, that's the O'Keefe family. Each side has 10 seats that they can have. To the far right is John O'Keefe's brother Paul, his sister-in-law Erin. Usually on the other far left side is his mom, and generally family and friends are sitting there with them. And there's also a victim's advocate that sits with them that rotates in and out, that lets them know when disturbing information is going to come on so they can leave the courtroom.
Sue, as always, thank you.
Thank
You're
you.
welcome. You're welcome.
Looking ahead to next week, the case is expected to be in the hands of the jury by midweek.
Before deliberations begin, you can catch up on past episodes of Canton Confidential online at NBC10Boston.com and the podcast version of our show on multiple platforms.